Buckle up, folks, this is one courtroom showdown you won't forget. What starts as a hit-and-run turns into a fiery clash between a judge and a commercial driver with a criminal past. She claims racism. The judge accuses recklessness, and somewhere in between, there are allegations of deliberate collisions, mental health struggles, and raw emotional breakdowns. Miss Gill, a single mother on felony probation, faces the full weight of the law after allegedly sideswiping another vehicle not once, but twice. Her reason: she was hungry. What follows is a tense courtroom exchange packed with legal twists, emotional outbursts, and a judge who's had enough. Let's get into it.
You've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Oh, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay, good.
On March 25th, 2025, officers were dispatched to 15357.
Okay, let's pause right here. Miss Gill is already in hot water. According to the report, she not only hit another car but refused to stop and exchange information, a clear violation of Texas law. Legally, this falls under failure to stop and give information, or FSGI, which can be classified as a misdemeanor or felony depending on the damage. And let's not ignore the fact that the complainant followed her for 3 miles, which raises serious questions. What would you do? In that situation, keep following or call the cops immediately.
Vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallsville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited.
This is the moment where things take a dramatic and dangerous turn. The complainant says Miss Gill backed into her a second time, this time intentionally. That changes the legal stakes completely. If proven, this isn't just hit-on, could border on aggravated assault with a vehicle, especially if there was intent. And when the judge asks, "Are you telling me it was intentional?" you can feel the entire room shift. Intent matters in the law. A mistake is one thing. Intent is a whole other monster.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle.
Boom. The judge isn't holding back. After listing Miss Gill's criminal history, including felony probation for assaulting a peace officer and injuring a child, he makes one thing crystal clear: I am taking away your privilege to drive. That's a serious move. Especially since she's a commercial driver with a CDL, meaning she's held to higher legal standards. The message is clear: public safety comes first, and this court is done giving second chances.
Finish.
I'm so
please.
sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine.
What we're seeing here is a judge pushed to his limit. He's not just punishing a crime, he's warning the community. The phrase "you are a danger to the public" carries serious weight, especially in a case involving multiple active charges, including evading arrest and now FSGI. Let's not forget, with a commercial license, one conviction can end your career. So the stakes here are as much about freedom as they are about livelihood.
So now, this is an affidavit, and I hope that you take it seriously, because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor. May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. She has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnosis.
This is where the case takes a more human, complex turn. Miss Gill's attorney reveals that she's unmedicated, has a mental health diagnosis, and has even applied for mental health court. Legally, this matters. Texas has specialty courts for individuals with verified mental illness who commit nonviolent offenses, but that doesn't guarantee sympathy. The question becomes, do mental health challenges excuse repeat criminal behavior, or is personal accountability still paramount? What do you think?
Technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey.
This is one of the rawest moments in the entire courtroom. Miss Gill breaks down, saying she was beaten in front of her children, that her kids have trauma, and that she hasn't had access to medication or insurance. Whether you see this as an excuse or a cry for help, it's gut trenching. But then she brings race into the conversation. You don't understand me because I'm colored. It's a painful statement. Whether you agree or disagree, it exposes the deeply emotional, racial, and systemic tensions that exist in these kinds of courtrooms every day.
And I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication. And I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
okay?
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
it's
not.
so true. It's so true. And you know this. You know what I'm talking about.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. If they're a small farm animal, I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes, really?
Officer Harris did not read me my rights.
Well, I will
They've been mishandling me like this for years already, okay? I have the right to tell you this.
And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now. All right? I'm not gonna raise it to 5, but I can't continue to give you a PR bond.
Terminated from employment too.
Listen,
Okay.
do not drive. It's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case.
sir. Yes, sir.
And just, all right.
So what just happened here? Miss Gill, already on felony probation, now faces 4 open cases, including FSGI and evading arrest. Despite her emotional testimony, the judge stood firm, emphasizing public safety and revoking her right to drive. Mental health concerns, racial tension, career loss, it all collided in this one courtroom. And the question that lingers, can justice and empathy truly coexist in a system this strained? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns every week. Stay informed, stay aware.